Okay, we have Ms. Morris. I could see you. Good morning, ma'am.
Good morning, Your Honor.
And we'll wait for Ms. Anna Hargret. Let's see. I see her name. I see her name on the screen, and let's see if she could sign in. Okay. Good morning, Miss. I got you. Can you hear me, Ms. Anna Hargret?
Yes, I can hear you.
Very good. All right, so we're ready to proceed on the next case. That's our docket, and for the record, it is City of Tampa versus Keith Smith. And on behalf of the appellant, we have Ms. Toyin Anna Hargret, and on behalf of the appellee, we have Ms. Alina Moros. All right, and just to remind you both, you have 20 minutes to make your argument, and as appellant, Ms. Hargret, is it Ms. Anna Hargret or just Ms. Hargret? How do you wish for me to address?
Either's fine. I tend to go by Ina Hargret.
Then let me do Ina Hargret. I'll do that. All right. And how much time do you wish to reserve for rebuttal, ma'am?
3 minutes.
3 minutes? Very good. And whenever you're ready to proceed.
Okay. Good morning. May it please the court. Again, my name is Toyin Ina Hargret, and I represent the City of Tampa, the defendant below, and the appellant here today. And as I've indicated, I'd like to go ahead and reserve 3 minutes of my time. The 1 or 1.5 minute background regarding this case is that it's basically a classic motor vehicle accident involving a TPD officer responding lights and sirens to the USF campus due to an armed shooter call. Our officer pulled out from behind stopped traffic, entered an intersection, and attempted to make a right-hand turn when he was struck in the rear of his unmarked Ford SUV. The contention within the case is that the city believes that the vehicle in which the plaintiff was a passenger was struck, and that the driver of that vehicle failed to comply with 316-126, which requires vehicles to remain stopped. And the plaintiff's position is that the city's vehicle actually sideswiped the plaintiff's vehicle. At trial, there were 5 issues that I've raised with this court that I believe need to be addressed, and which would ultimately either jointly or separately require remand. The first issue is regarding the plaintiff's statement against interest. The plaintiff, who was the front seat passenger in the vehicle that we believe struck the back of the city's SUV, made statements after the accident to a medical provider indicating that his driver freaked out, and she continued driving into the intersection.
So if I could just ask you there, first of all, this is like your worst nightmare. You have an accident with a police cruiser. I'm sure that was like unbelievable to everybody at the scene. It's even more amazing that the other driver prevailed in the lawsuit, which is also amazing. But so I want to focus on this because there are a lot of things going on with this issue. There has been a discussion about whether it's a statement against interest by a passenger, not the driver, and or whether it's an excited utterance, which I think you've taken the position that's not what we're arguing here. Am I right about that?
You're correct, Judge.
Okay. And then there's this position that a layperson can testify about, sort of a reaction that another layperson has to an incident, right? So those 3 things are at play here. So I'm going to take the excited utterance off the table because you're not arguing that, and we're not. That was that altogether. The brief spent too much time talking about something. It became clear to me at the end that you weren't arguing in the first place. So a statement against interest, that seems to be where you're headed with this. And this is a statement against interest of the passenger, not the driver.
Yes.
Right? So, I mean, I'm just, to me, a statement against interest would be something that the driver would have said, not the passenger. So help me with that part right there. Help me with that.
Yes, the reason why the statement by Mr. Smith was a statement against his interest is because, as you can see in the actual medical report, he'd already lawyered up. So he actually hired the same law firm as the driver, and the cases were actually consolidated in the circuit court for a period of time. So based upon the fact that he has already hired a lawyer and he's now making statements that the driver of his vehicle was actually at fault, that would go against his interest with respect to his lawsuit. So that's the position that the city was presenting. And there actually was no argument below regarding the fact that it was a statement against interest. The argument was that the plaintiff, appellee, felt that this statement was actually a commentary on what the driver was thinking. And I spent a bit of time in my brief explaining that a layperson can certainly characterize what he observed. And what he observed is that his driver had some behavior that he identified as constituting her freaking out and driving into the intersection. That's important. That fact is very important to the city because at trial, the plaintiff was stating that his driver just inched into the intersection and remained stopped. That is inconsistent with freaking out and driving into the intersection.
But is it really? I mean, freaking out is, I'm not, that's one of these sort of things that you really understand what freaking out is when you see it. It's hard to define, but you know it when you see it, right? So how does that have anything to do with how far she did or did not creep into the intersection?
The reason why it has something to do with it is because that was the plaintiff's, in my belief, attempt to kind of backpedal from his statement that she simply drove into the intersection.
But I suppose the way that I'm looking at it, that term freaking out, let's push that aside. The bottom line is the contents of his statement as to what had happened in terms of the driver being at fault and going into the intersection. That was provided to the jury. The jury heard that. The only thing that the judge basically indicated that term freaking out, because you're basically, and here's at least my take on this, the term, if I say someone's freaking out, it is basically, I am injecting my speculation as to what you're thinking at the time of the incident itself. I'm sure a number of us have had incident people say, oh, don't freak out. And you're like, I'm not freaking out. This is just, so that's where the speculation comes in for that term freaking out. But the bottom line is, when you're dealing with an abuse of discretion standard and what effect it had to the jury, your whole purpose in providing that statement is to bring up the fact that the driver was at fault and enter the intersection where she should not have had. And that information was in fact provided to the jury. Am I correct?
I don't believe so, not with the benefit of having the jury see his credibility. At the time of the accident, it's clear that Mr. Smith felt his driver was at fault because of her aberrant behavior. Now, because he wouldn't repeat that statement, he wouldn't repeat that position, I don't have a way of having him explain what it is that he saw or observed. He simply would not do that.
But going back to Judge Kuzam's point, isn't it really what matters is what they testify as to what she did, than as opposed to what expression she may have made? I mean, for example, we could take another set of facts where somebody slams on the brakes, immediately does everything perfectly, but everybody in the car says he freaked out. What's it got to do with anything?
I think what it has to do with that is there's also a layering effect. When you look at the fact that he stated, in a sense, that by freaking out and driving into the intersection, his driver was at fault, he also repeated those statements to the investigating officer, Officer White. And so it's not only just that statement, it's also the consistent statement to Officer White. And that would be the second point of error that the city raised, which is that the accident report privilege, which this District Court of Appeal has actually said is not actually a privilege. That privilege does not apply here because Mr. Smith was never in jeopardy.
How does it not apply? We're looking at the statute. It's someone who's involved in the accident. And we have here an occupant of the actual car that's involved in the accident. And I believe some of the cases that you have cited to deal with witnesses that were actually not involved in the accident. Can you help me out with that?
Yes, Your Honor. When you look at the plain reading of the statute, it says, and I'll read from it, each crash report made by a person involved in the crash and state any statement by such person to a law enforcement officer for the purpose of completing a crash report by this required by this section shall be without prejudice to the individual so reporting. And so I think that that's the key thing. There's nothing about his statement to Officer White on the date of the motor vehicle accident which would have been to his prejudice. It's those statements that may not be used in any trial. And the fact is,
you're injecting some words that are not actually in the statute there. So, you know, he's obviously an individual who's involved in the accident, making a statement for the purposes of the police investigation. The words of prejudice that you're injecting are not seen in the statute. You would agree with me?
I'm reading from it now, and it says that by without prejudice to the individual so reporting. That's what I'm that's what I'm referring to.
Okay, right, but without prejudice to him so reporting, but his statements are part of the officer's investigation, right? Because he is someone who was in the car, who is involved in the accident.
He is, and from a very technical standpoint, he is involved in the accident, and he's required to give the basic information that I outlined in my brief, which is basically demographic information, time, place, location of the accident, whether he was a driver or passenger, and the name of the other individuals who were involved and the names of any witnesses. In fact, the badge number and name of the officer is also included. And that's what's actually required, nothing more. And then when you...
And the point of, excuse me, can you hear me?
I can now.
Okay. And the point of that statute is to make sure that people are freely giving the information. And so it is not unreasonable, because this is what happens when people are involved in an accident, people are injured. And so the statute is designed to protect that they give statements to the officer so that the officer can do their job and without prejudice to them. So why would this statute not protect this occupant?
I think it goes to the way that you frame the question, which is that it's not with any prejudice to Mr. Smith. It never was. I think that's the key issue here. Nothing he said, he was not the driver. He was not subject to being cited, not subject to any criminal charges. He wasn't then and he isn't now. And there's nothing, granted, the testimony from Officer White included that he had investigated the driver. He talked with Mr. Smith, another passenger, and an independent witness. All of their testimonies aligned, and stated that the vehicle drove forward into the intersection. But the city was never attempting to introduce the testimony as it related to the driver, because it would have been with prejudice to her. She was the driver. But as a passenger,
danger, I guess what I'm concerned with, by doing precisely what you're asking us to do, it would throw that whole statute out.
Definitely.
Because the whole purpose of the statute is to, as Judge Smith and Judge Morse indicated, to have people freely. This is a search for the truth. What happened here? Be comfortable. Tell me exactly what happened. These words are protected. And the word without prejudice means don't worry. Don't worry about what you tell us. We want the truth. Search for the truth about what really happened, and to allow inch by inch to, oh, that's not going to hurt you. Isn't that a way of chipping away and then ultimately defeat the whole purpose behind the statute?
I think to rule otherwise and not strictly construe it the way that I'm advising is would kind of throw a monkey wrench into everything, because that way you have a situation where someone at the scene of an incident can say, oh, my driver was not at fault, and later on change his mind and testify differently to his favor. The purpose of the statute is not to offer a passenger the ability to protect the driver. It's for each individual to be protected themselves. But again, here, there's no, there was never any risk. There was never any jeopardy for Mr. Smith. And
so how is the police officer at the scene supposed to explain to the participants the accident report privilege when he starts asking questions? When people clam up, typically an officer will say, no, this is pursuant to the, they'll change their hat even. They'll say, I'm doing a report for the accident report privilege. And when they're done, they'll say, I'm done with this. Now I'm putting on my criminal hat. In the case of a criminal investigation like a DUI, they're very definitive about that. And they explain to the people at the scene the accident report privilege. So you're now asking an officer to figure out at the scene who's in jeopardy, who's not in jeopardy. In other words, he's becoming a mini judge at the scene to be able to advise these people, well, you can talk freely, no worry, accident privilege. But if you talk freely, you don't have any jeopardy here, and perhaps it's going to affect that. You're creating a nightmare here if we were to follow what you want.
I don't think that at the scene, the typical officer would have to explain that.
Well, they're going to mislead people then. They're going to say, I'm pursuant to the accident report privilege, I'm going to ask you information. You all can talk freely, and you're not going to in any way it will be used against you. So they're going to be lying to people.
I don't think they would be lying to people. They would be investigating, they would be interviewing people, and the determination regarding jeopardy is one that would be made later.
Yeah, well, but people are speaking freely under the basis of they're being told that this is pursuant to the accident report privilege. So now people have been induced to talk, thinking that it won't be used against them or anybody else in this action. And later they find out, no, that's not the case, because you were in jeopardy, but you weren't. I mean, it's a nightmare.
Judge Morris, I think that's the key point, what you just said, which is that people will be talking, thinking it won't be, they won't put themselves in jeopardy, and they won't. That's what the law requires. But there's no requirement that their statements not put someone else in jeopardy. Well, that's not found in there.
And that's what I'm saying. You're putting a police officer in an impossible situation at the scene to try to explain that to people. And they need to. They should. They can't create this inference that they're safe conversation under the accident report privilege and let people later find out, well, no, not exactly. That's not exactly how it works. You know, that's not the country I want to live in. That's not how we do it.
Well, I disagree to the extent that I really do feel that the average person in an accident is going to speak freely unless they feel uncomfortable because of something that they themselves did. And in that case, the law is designed to protect them. It's designed to make sure that they do not self-incriminate. There's no requirement that you don't incriminate the people around you, but you should not be self-incriminating. That's the protection that we hold for people, because the reporting is mandated by statute. So of course, we want to encourage people to go ahead and report. And so that was the city's position with respect to the fact that Mr. Smith admitted that his driver freaked out and ran into the road, and admitted that also to the officer. And those statements together should have both been admitted before the court. The third issue, can
I interrupt? You're right. You have 3 minutes left for rebuttal. You reached that point, so it's up to you. Do you want to go forward, or do you want to save it for rebuttal?
I'll just take a minute just to state that with respect to Dr. Wilson, it's clear to me that a witness is not allowed to testify as to the abilities of another. That was the subject of the plaintiff's 6th motion in limine, and they should not have been allowed to do that. What they did was to bolster their own witness and to diminish the testimony of the city's sole witness. I reserve my remaining, I think, 2 minutes.
Very good. All right, ma'am, you have 2 minutes left for rebuttal. Okay, Ms. Morris, you may proceed, ma'am.
Yes, hi, good morning. May it please the court, counsel. Appellant in bringing this appeal enumerates 5 separate instances in which a trial court allegedly committed reversible error. Appellee disagrees with each of these instances and asserts as follows. First,
can I trouble you, Ms. Morris? I want you to zero in. I know we haven't had a chance to talk on the appellant's presentation, but with respect to the trial courts limiting the expert's opinion as to causation, can I have you focus on that really quick?
Yes, Your Honor. So that would be the third issue with regard to the trial court limiting Dr. Wilson's opinions as to essentially orthopedic injuries and rheumatology in an emergency room setting. So to give you a little bit of background, appellant hired a board certified emergency room physician, Dr. Wilson, as an expert to perform a review of appellee's medical records and diagnostic films, primarily concerning his DVT episodes, and ultimately to conduct a compulsory medical examination at some point in the future. Appellant hired this expert multiple years, prior to appellee undergoing orthopedic hip surgery. This collision occurred in 2013. The appellee underwent orthopedic hip surgery in 2018, and I believe the doctor was hired sometime in 2016 by the appellant. I don't have the exact date available, but it was a couple of years before his surgery.
No,
So
and I understand the whole sequence about how they weren't going to use an expert, then finally at the very last minute they did. But my understanding of the court's ruling was that this expert was not qualified to render an opinion as to causation by virtue of the fact that he was simply an emergency room physician. Even though he could testify as the DVT, he could testify about the arthritis, but he cannot testify as to the causation. With this, because this lawsuit happened 6 years after the fact, that basically, as I understand that the court said, you cannot talk about the causation. So the judge didn't make a ruling that because the city failed to list him until the last minute and didn't indicate what he's going to be testifying on, didn't exclude him from testifying to causation because of that. Simply, as I understand the judge's ruling, is that you're not qualified, and because you're not qualified, you cannot render that opinion. Is that pretty much it?
yes, Your Honor. The judge did go and did a very thorough and thoughtful analysis as to this expert's qualifications. She delved into his knowledge, experience, training, and background, and found that he could testify as to orthopedic hip injuries in an emergency room setting. He could testify as to the presence of arthritis in a hip and being able to identify it in an x-ray in an emergency room setting. However, as to orthopedic hip surgery and the need for orthopedic hip surgery and the progression of arthritis over time after an injury, the judge felt that his experience was limited based on his own testimony. His own testimony
was— Isn't the threshold very low to determine expert testimony? It doesn't take much. It's simply testimony that will aid the trier of fact. So what would be the, and I guess the second part of my question is, was the testimony proffered?
No, Your Honor, the testimony
wasn't proffered. So we don't know what this expert would have said, right?
As far as proffering the testimony, no, Your Honor. His testimony was not proffered for purposes of the trial court. His testimony was taken via a video trial deposition. And we did go over the questions and answers. And there are a series of questions and answers that both the appellant and the appellee as well included, wherein the judge was doing a thoughtful analysis as to what he was able to testify and what he wasn't able to testify. But ultimately speaking, as to the need for orthopedic hip surgery, again, he's not an orthopedic hip surgeon. He doesn't have that training and experience. And though the threshold is low—
isn't the threshold really low?
The threshold is low, Your Honor, but the expert himself testified that he does not make any decisions regarding orthopedic hip surgeries, that he's only in an emergency room setting, he just identifies the injury and then calls in a consult of an orthopedic hip surgeon to determine whether that person needs the surgery or not. So
what's the strongest authority you have to support the trial court's decision on this issue? The exclusion of testimony is a pretty serious thing. And well, with a low threshold, it becomes even more serious. So help us point to the authority that says that judge was right. You should affirm the judge.
Well, yes, Your Honor. If you would just give me one moment, with regard to his qualifications and with regard to the analysis that the judge did under the Daubert analysis that she did, she essentially found that he wasn't qualified to do so. He wasn't qualified to provide opinion testimony in specifically his field where he has no specialization and no experience himself in. And so that essentially that is the appellee's position. This individual, this expert that was presented to give testimony for purposes of the jury and to assist a trier of fact in determining whether this individual had a progression of injury over a period of time that would lead to a cause for orthopedic hip surgery, had no training, experience, and background in this specific specialization to provide information that would assist that trier of fact in making a decision versus what an orthopedic hip surgeon or a board certified orthopedic hip surgeon would have done. And in this case, it is not the trial judge's.
Well, isn't that the subject of a closing argument? You know, our expert's better than our expert, you know, type thing. I mean, that's the problem I have with this is it's hard to see what harm. I mean, the three Daubert requirements of qualifications, reliability, and assistance to the trier of fact, there's no doubt that what this doctor would have said would have assisted the trier of fact on this issue in some way, whether it's a lot of assistance or a little assistance is something for somebody else to argue. You know, reliability, you know, again, this was a very experienced, credentialed ER physician. It wasn't like this was somebody just got out of med school last night. This physician had been around the block quite a bit, and the qualifications this physician had were extensive. Yes, he was not a hip surgeon and didn't do all that, but you can't. It wouldn't be like me testifying on this. I mean, I wouldn't know anything, but you know, it would be somebody who had a reasonable background that should have been considered.
Well, Your Honor, again, respectfully, I disagree. I think that the trial judge in this scenario went through all of his qualifications and background. She went through his CV. She went through his testimony and what all the research and everything he's done as far as his experience and qualifications. She found that he absolutely was qualified to testify as to DVTs, the original reason he was hired. She found that he was able to testify as to identifying an orthopedic hip injury in an emergency room. She found that he was able to testify and was qualified to testify as to identifying what arthritis was in an emergency room setting. However, he is a very qualified physician. It's true. He did not just graduate from medical school, as Your Honor posited. However, he has no experience in orthopedic hip injuries. He's never performed an orthopedic hip surgery. And so when you're giving the trier of fact.
Ms. Morse, if I may, and I understand this is the position you're taking, but if you look exactly what he was asking to respond to a specific question was as follows. He testified about his experience with arthritis, with DVT, and then he was asked, he was prohibited from saying is that, look, if you look at the X-ray, it looks, you know, if he had a bruise, that bruise would have dissipated long ago. We're now dealing 6 years post-accident. And what he was trying to say is that I don't anticipate that. I mean, with the bruise will go away, the pain will go away. So he was trying to say that under his experience with arthritis, with DVT, that he was prohibited from going to the next step by saying, it just seems odd to me that 6 years post-accident, he would have needed, you know, to have that surgery. So he's not testifying as to his expertise as a hip surgeon, but in his expertise dealing with the guy's arthritis, the DVT, that's the posture that was put in. And I really think, you know, and having said all that, I think your strongest point is that there was no proffer in this case.
Yeah, that's the
question is, with it being no proffer, was there a waiver? But I'm just troubled by what the judge did.
Yes, and yes, Your Honor, and that is why a portion of our answer brief discussed the fact that there wasn't a proffer for many of the points that the appellant was bringing up. However, with regard specifically, again, to your point as to Dr. Wilson and the progression of arthritis, Dr. Wilson does not have experience of the progression of arthritis over time. Dr. Wilson has the experience of being able to identify arthritis in an emergency room setting and say that is arthritis. However, what the trial judge did and the analysis that she entered into was to go into his experience and say, you've never followed the progression of a patient. You've never followed the progression of an arthritic patient to see if in fact he's gonna require surgery from this injury, or if he's gonna require surgery at some point in the future over arthritis. At that point, he was just essentially speculating because he doesn't have the experience of a rheumatologist, because the trial judge went into that, or as an orthopedic hip surgeon. So for those purposes, aside from the fact, which I think, and I agree with Your Honor, that the strongest point is there wasn't a proffer of this testimony, that for the testimony that wasn't admitted, but specifically aside from that, based off of, I mean, there was a motion in limine. The judge went through every single qualification and found that he wasn't eligible to testify as to these specific issues. There was a motion for reconsideration, which again, she went into another thoughtful and detailed analysis as to his experience and background, and again found he does not meet the threshold or the qualification, as low as the threshold may be for the qualifications. He does not get to that point, and therefore he should not be providing opinion testimony as to the need for orthopedic hip surgery after a period of time following an injury. And so for those reasons, Your Honor, we believe that the trial judge properly limited his testimony. And again, the testimony was not proffered by the appellant in this case in order to be able to preserve it for review on appeal as well. And so I would like to go back for a moment, if Your Honors don't have any further questions with regard to that, and just address, if I have, I've not been keeping track of my time, but just address a couple of the points that.
You have time. You have time. You're good.
Okay, but I wanted to address the freaked out comment for the first issue that the appellant brought up regarding the driver's state of mind. As Your Honors properly brought up in this instance, the only words that were kept out of the statement were the words freaked out, okay? The trial court did not allow the words to be presented to the jury because it ruled that it went directly to the state of mind of the driver of the vehicle she was feeling, violate the very same first motion in limine that the appellant filed that went to prohibit any testimony regarding belief or speculation as to what a driver was doing, thinking, or feeling at the time of a motor vehicle accident. And so the appellant would like the opportunity to confront and to bring this testimony in by virtue of this court analyzing this. However, the appellant did not go and was not prevented from providing the rest of the statement. The rest of the statement is arguably the strongest part of the statement, wherein he essentially talks about his driver going into the intersection. The words freaked out have never been defined by anyone in this case. And I wrote down on a note where the appellant—
Yeah, but we all kind of know what that means. I mean, isn't that a common understanding? Like I said earlier, I mean, it's kind of hard to describe, but you know when you see it, you know. I mean,
right, Your Honor, but as Judge Kasem also was saying is, and I think you were saying as well, somebody just braking suddenly could be called somebody freaking out, and the driver say, "Hey, I'm not freaking out."
All right. Well, you could have behaved perfectly and allegedly freaked out. You know?
And that's the point. It's subject to interpretation, and it's the thoughts of somebody else and the opinions of somebody else. And it has nothing to do in this instance with specifically an action. And again, we don't know when the words freaked out were written in the medical report, we don't know what those terms meant to the appellee. Yeah. Counsel for the appellant testifies that my client refused to define those words. The fact is, my client was never even confronted with those words at his deposition, though they had the ability to do so. He was never asked what freaked out meant in that context. The driver of the vehicle was never confronted with his statement, though they had the medical records and they had the statement months before her deposition was taken to ask her, what did you do? Why is he saying they freaked out? He was never even asked what her demeanor was in the vehicle. Counsel for the appellant claims that there was some sort of aberrant behavior. That's a supposition. that's being placed on my client with the words freaked out, because we don't know. Those questions were never asked, and the testimony, again, it's another instance, was never proffered. Outside of the presence of the jury, my client was never asked, what did you mean when it said freaked out in the testimony, in the medical records? Can you define that for us in the medical records? That was never asked of my client at all. And so for those reasons, I think, and aside from the fact that the rest of the statement came in, which arguably is the reason why the jury likely put 50% of the fault on the driver of the vehicle, and was the strongest part of that statement, which was that an emergency vehicle was coming up behind them. The driver tried to pull over, but didn't keep her foot on the brake. She continued into the intersection. You don't need the words freaked out to convey to the jury that he says she went into the intersection. And so for those reasons, we believe that failure to proffer his testimony to even find out what the word freaked out meant to him, it wasn't proper, and I don't think the issue was properly preserved on appeal. With regard to the accident report privilege, I'm just trying to move along here. The accident report privilege was meant, as they state in Bracken v. Bowles, that the purpose of the statute is to clothe with statutory immunity statements and communications as the driver, owner, or occupant of a vehicle makes to a police officer at the scene of a collision. And that privilege extends to all persons within the ambit involved in the motor vehicle collision. In this situation, there's no question that my client was involved in the collision. There's no question that the officer that took down the statements was the investigating officer and was asking questions for purposes of determining fault, for purposes of the collision. And there's no question that he created a police report. It's well settled law in the state of Florida, and to have the appellant engage in a sort of theoretical exercise to argue that because my client, who was a passenger in the vehicle, was not in some sort of jeopardy, that a statement should be introduced to the jury, again, as properly identified by your honors, it's just, that's not what the statute was meant to do. It was supposed to protect all occupants and provide immunity to all occupants of a vehicle involved in the collision itself. And so the other argument is that the appellant is suggesting that somehow my client was not required to answer any questions posed by the officer other than the 6 items that were listed: the date and time and collision of the crash, a description of the vehicles, the name and address of the parties involved in the identification of vehicles in which each was a driver or passenger, the names and addresses of the witnesses, the name, badge number, and law enforcement agency of the officer investigating the crash, and the names of the insurance companies for the respective parties. Though that's what the statute requires for the officer to make sure that it's included in his police report, that's not the only thing that's privileged. There's nothing in the statute, nothing in Florida case law to suggest that what the appellant seems to be suggesting, that a passenger of the vehicle is exempt from the duty of answering the investigating officer's questions as to how the collision occurred or what their recollection was of the events at that moment. And secondly, in the statements, I also took down a note here that allegedly the appellant was just telling the court that my client made the comments freaked out or said those exact statements to Officer White. First of all, Officer White never testified to that. What Officer White testified to was what the driver of the vehicle said to him. That's the only thing that was included in the police report, that there were lights and sirens on, and then that the passengers of the vehicle confirmed that description. There was actually no statement specifically made regarding words that my client said to Officer White. And of course, then the most important part is, and I think Your Honors referenced it previously, is that the majority of the statement that appellant wanted to bring in already came in by virtue of the medical records, right? The statement that we were just talking about in the medical records of the vehicle that my client was in was proceeding into the intersection and collided with the vehicle from the police officer as it was coming around and responding already came in. So there would be no reason for the trial court to come in and admit a statement into evidence that's already protected via statutory immunity, and in this case being the accident report privilege. Another point that the city made in their appeal had to do with, and I think she referenced in the last minute of her initial comments, was regarding the expert presented by the appellant making comments or improper comments about the
And
ability.
if I may, Ms. Morris, for some reason my chime didn't go off, but you've reached your limit, so.
Okay, if I just may then, Your Honor, and for those reasons, I ask that the trial court's findings not be disturbed and the case affirmed. Thank you. Thank you all for your time.
Thank you, ma'am. All right. So Ms. Ina Hargett, you have 2 minutes, ma'am, for rebuttal, okay?
Sure. And I guess I want to quickly state that there was the other issue with respect to the appellee bringing up evidence that had not been admitted in closing argument, and not only just bringing it up, but actually testifying to it, which was improper and gave her the plaintiff's position an unfair advantage. And then with respect to the issue of whether or not the information is available for review and had been proffered with respect to Dr. Wilson, his testimony had been filed with the court. It was clear to the court what his testimony was going to be. Was his full transcript read into the record? No. However, his record had been filed in the record of the court. It's available for review. And the court actually went through it line by line as we went through the objections with respect to the designations for the jury. So there, at this point, really, it's a technicality, but the record was in front of Judge Peacock, and she had it for review with respect to what Dr. Wilson would have stated, and that information definitely would have been helpful to the jury. So with that, I would say that the city would rely on its initial and its reply brief and would ask the court for remand. Thank you.
Thank you both, really well argued on both sides. Thank you all. Okay, and if at this time, then we're going to ask you to please remove yourselves and